Hello everyone, attorney Carlos Colombo here from Colombo and Hurd, and today we're going to talk about the three biggest mistakes that applicants make when applying for an EB-2 National Interest Waiver. So stay tuned. So today, first of all, I wanted to welcome everyone to our channel. I just finished a national, actually international news cast with Telemundo, Un Nuevo Día. As many as you know, I am one of the experts that NBC Telemundo uses for immigration matters. So I thought it would be a great time, since we're all here at home and I'm dressed up for the occasion, to talk a little bit about what are the three biggest mistakes that we are seeing applicants making with applications for EB-2 National Interest Waivers. So let's go. Well, let's talk a little bit about what it is to apply for an EB-2 National Interest Waiver. Let's remember that there are different categories that one can apply for a green card. There's EB-1, EB-2, EB-3, and so forth. The EB-2 category is for people that have either an advanced degree or exceptional ability. You don't need both, you need just one of them. So if you have a master's, a doctorate, or a bachelor's degree and 5 years of experience in your profession, then you meet that prong. The second basic requirement is you either have an employer that files your application under the EB-2 category, or you are in the national interest. You're applying in the national interest, which is called a National Interest Waiver, which basically says you do not need that U.S. employer to petition for you. You can do it yourself. It's called self-petition, which means you don't need to go through an employer. Obviously, that is a huge benefit because, as we all know, it has been increasingly difficult to get employers to sponsor an applicant, be it for an EB-2 or an EB-3, due to the delays in processing, the cost, and also in practice, a lot of people that already obtained the green card are technically free to work anywhere else. So sometimes employers don't want to make that investment if the person could potentially leave their place of employment. So the EB-2 NIW has grown in popularity, but we are seeing, as a result of that growth, a lot of people making drastic or severe mistakes that may render their application deniable, and also limiting their cases, because once you present that case to immigration, it's very difficult to then go back and fix it. So what are those three main mistakes that we're seeing? Number one is not understanding, either the attorney or the applicant, not fully understanding the requirements under DANASAR. DANASAR is a case that came out at the end of 2016, which really changed quite a bit how an applicant may qualify for an EB-2 NIW. And there are different aspects of DANASAR that are new. And it took a little bit of time, really, through 2017, 2018, and part of 2019, for immigration to adapt their officers, the officers reviewing your case, as to how to apply for an NIW. How is immigration going to interpret that new case, DANASAR? So we are seeing now, after some time, how immigration is questioning applications under the DANASAR requirements, and seeing that a lot of applicants were not advised correctly as to what the requirements really meant, or how immigration may consider that. So if you have a case that has either been questioned or denied, You may sometimes want to get a second opinion, making sure that the attorney understands how DANASAR should be applied. It's always very important to understand those requirements and have an attorney that has gone through DANASAR applications that have been either denied or questioned to make sure that they're applying the latest requirements under the DANASAR prongs. That's number one, making sure that you're following what I call the new law for NIW, which is the DANASAR standards for your case. Number two is obviously making sure that you hire an experienced immigration attorney. We are seeing, again, due to the growth and the popularity of NIW applications, it seems like there's a lot of attorneys, a lot of law firms that claim to have experience in EB-2 NIWs, and they really don't. So you have to make sure that the attorney has that experience. You have to make sure that they understand the requirements, and you're going to get that feeling in that consultation that you have with the attorney. A lot of times people ask for statistics. Statistics do matter, but your case is an individual case. So you have to find the attorney that will work with you individually to make sure that you're presenting your case, to make sure that the immigration attorney understands your case and your background, and that is presented on paper, because remember, this is all on paper. You're not going to have an interview about the requirements for the EB-2. It's all going to be presented to an officer in writing to make sure that is all, that it states the entire picture, and going back to the DANASAR requirements, that both you and the attorney are working together to make sure that happens. So hire an attorney that has experience. A lot of attorneys may claim, but make sure, look and see how long have they been practicing. Do they understand the basic requirements? Inform yourself of those requirements. Ask those tough questions to make sure that you feel comfortable with that. And then number three, of the errors that we usually see people that want to apply for an EB-2 NIW is being scared of what some of those requirements may be, and folks that believe that some of the older requirements are going to mean that you do not qualify. So to give you an example, before DANASAR, citations, a lot of publications and citations was something that was very important. That continues to be important, but it is not a factor that will be determinative for your case. Some professions require more publications than others. Some people may have very limited or no publications and can win an EB-2 NIW without any of those citations or publications. It depends on your field. Remember, before DANASAR, the professions that could qualify were more limited. So typically it was researchers, scientists, doctors, people like that would tend to apply for an EB-2 NIW. DANASAR opened that to a lot more professionals. So nowadays, you can be an entrepreneur, you could be an artist, you can be a person that has exceptional ability in different fields. It doesn't have to just be science for you to qualify. So don't be afraid, and then maybe you're talking with someone that, again, doesn't have that experience under DANASAR to apply the new requirements that has opened a little bit who could qualify for an EB-2 NIW. So at the end of the day, if you take one message from me today, is make sure that you hire qualified counsel, a qualified attorney to help you with your case. What we're seeing is a lot of attorneys that are charging very low fees just to have volumes of cases. What you want is to make sure that you have one good shot of winning your EB-2 NIW and have a firm that will fight for you and make sure that case gets approved. Statistically, it is a great number of cases that do get approved, so it is a great option. And remember, you're applying for U.S. permanent residency, the green card. So that has a value. Don't go for the cheapest option. It doesn't have to be extremely expensive, like some firms are charging. But also, if it's very low, be aware there may be something going on there. So I hope you guys enjoyed this video. If you have any questions, here is our contact information. Feel free to contact us. We can do a free evaluation of your background for an EB-2 NIW or any immigration case you may have. We're always here to help. God bless, and I hope that everybody stays safe. And please, if you have any needs for U.S. immigration, give us a call or email us. Thank you very much.